Okay, Nancy, I think that we may be ready to start.
Wonderful. Welcome, everyone. We have a great turnout today. I'm sure you are all wanting to jump in and learn more about these recent changes impacting most businesses. We ask that if you have any questions to enter them in the Q&A. I know we have a lot of content to cover in a short period of time, and we will try to get to as many questions as possible. We do have upcoming webinars where we will break out some of these changes into more detail. So please keep an eye out for those upcoming webinars. We have muted everyone and request that there not be any AI recording tools used for this meeting. We appreciate you taking the time out of your busy day to join us for this information-packed presentation. We are going to go ahead and turn off our cameras now so you can really focus on the presentation. And with that, I'm going to turn it over to Brenda.
Thank you, Nancy. So my name is Brenda Bonilla. I am an HR assistant here at HR Partners. We've been in business for about 25 years here in Atlanta. So like Nancy said, we're going to turn our cameras off so we can focus on our presentation. Thank you. Okay. So to start, we're going to go over HR best practices. These are going to cover new laws, regulations, and policies, such as new 1099 laws, new W-2 exempt and non-exempt thresholds, walk-around rules that can affect OSHA, pregnancy and accommodation laws, federal and state laws. We'll touch on some documentation and security, and of course, best practices to keep you safe. So first, let's go over the 1099 classification. So as of March 11th, 2024, laws are now more comprehensive for 1099s. So we're looking at the totality of the circumstances instead of core factors of the past. So remember, state laws can be more stringent, such as in California. Um, and keep in mind that misclassifications can be costly to the organization, so fees would be involved. So be sure to double check your checklist or visit the DOL site, or you can always contact HR partners. And remember, just because an employee is classified as a 1099, it does not make them a qualified independent contractor under the new rules. So we want to focus on 6 factors. So to start, the worker's opportunity for profit or loss, core, this is actually one of the core factors before. The factor covers a worker's ability to meaningfully negotiate their price of services and goods. Then you have relative amount of investments made by worker versus by the employer. So who's the one that's buying the tools? The permanency of the relationship. Is there an end date? Is this project based? For the nature and degree of the potential employer's control. So are you the one directing the actual work? 5, the extent to which the work is performed and whether the worker uses specialized skills indicative of business-like initiative. Okay. So here we have this nice infographic from the DOL, and on the left you can see the indicators of an employee, and on the right-hand side we see indicators of an independent contractor, which we will focus on. So they're in the business for themselves. They can increase their profit through business decisions. They typically have their own materials and tools. They often work with multiple clients. The relationship is temporary, so whenever they finish the project, um, they decide how and when they will perform the work, and they get to choose what work or projects they take on. So always remember to ask those questions um, when trying to figure out if they are a 1099. So this is another major change affecting a lot of businesses, and it's classifying W-2 employees. So two dates that we want to keep in mind are July 1st, 2024 and January 1st, 2025. So as of July 1st, 2024, the pay threshold will be at 43,888 annually. And in January 2025, it'll be at 58,656 annually. So if we're looking at a list of our employees and we have some who are exempt, so meaning they're salaried and their checks look the same, let's say they make around 44,000, 45,000. Are we meeting the threshold and we pay them 58,656 but keep them exempt? Or are we keeping them at the same pay, but now they become a non-exempt employee? And this answer just depends on where your business stands. This is something that you, of course, would have to decide. How much OT or overtime will you potentially pay? So again, all things to think about. And remember, once they go from exempt to non-exempt, employees have to start logging in their hours, so clocking in and out for lunch. This is some time management that will need to be monitored. Next, we have walk-around rules, and we'll talk about what it now allows. So as of May 31st, 2024, OSHA's new walk around rule would allow employees and the employer to authorize a representative to accompany the OSHA compliance officer during inspection. So this representative does not have to be an employee of the company and must be reasonably necessary to assist with effective inspections. Now, we don't have many details on this yet, on what would cause someone to be qualified or found reasonably necessary. But this does open doors to a union representative that is not an employee to gain access if selected as the representative. So just something to keep in mind. Next, we have the PWFA, which is an acronym for Pregnant Workers Fairness Act. So this is going to be up there with like Title 7, ADA, FMLA, very, very important. This is going to go into effect June 18th, 2024. This will require employers with 15 employees or more to make accommodation if someone requests in relations to pregnancy, childbirth, or related medical conditions. Now, reasonable accommodations are changes in the work environment or the way things are usually done at work. Now, generally, the burden is on the employee to raise need if they need an accommodation, and as the employer, your responsibility is to respond. An employer is not expected to know without being told what the degree of the impairment, impact on job performance, or need of reasonable accommodation looks like without being told by the employee. Now, one exception of this rule or circumstance where the employer should be the party to initiate the interactive process is when an employer knows an employee has a disability, knows or has reason to know that the employee is experiencing problems because of a disability, knows or has reason to know the disability prevents the employee from requesting accommodation. So sometimes disability may be obvious and easily observed, such as an employee in a wheelchair, for example. In those instances, the employer has knowledge of the disability without affirmative disclosure by the employee. So that's when an employer can take action. So this is a screenshot of a flyer brought forward by the EEOC, and on the top it reads, if your pregnancy, childbirth, or related medical condition makes it harder for you to perform your job, you can ask for a change, called a reasonable accommodation. So this is how it's being presented to employees. As you can see in step one, it tells employees to talk to their employer. So that can be HR, their manager, or the person that's designated in the company policy. Next, they're instructed to explain that because of a physical or mental condition related to their pregnancy, childbirth, or related medical condition, the change is being requested. Third, they're told to share with their employer what barriers they're facing, and to give ideas of what could help them do their job. Um, and of course, you want to ask them what they think would help. You want to ask what their ideas are, and you can offer alternatives as long as they're reasonable. Now, number four does state if your employer says no, provide information, tell your employer about the EEOC's webpage. So then it would direct you here. Now, there is a lot of information on this website, but we wanted to make sure that you're aware of how it's being presented to employees. Okay, now pregnancy, childbirth, and related conditions. So this could be a current pregnancy, a past pregnancy, potential pregnancy, lactation. This includes breastfeeding and pumping, use of contraception, menstruation, infertility and fertility treatments, endometriosis, miscarriage, stillbirth, or having or choosing not to have an abortion, among other conditions. So related medical conditions. So that's a new physical and mental condition originating during pregnancy and pre-existing conditions that were caused by the pregnancy or childbirth. And the EOC does provide a list that we're happy to email you if you would like. But some of the examples given were migraines, morning sickness, appointments, contraception such as IUD, recovery complications, abortion time to get one, complications or IVF appointments. Again, the list is extensive. If you would like, we can email it to you. Now, please remember this law does apply to companies with 15 or more employees. Okay. Um, Now, these limitations do need to be temporary in nature, so that means that the employee can perform their functions in the near future. So again, there is no defined time frame. Um, if the employee is not eligible for FMLA or state leave, then approach it as an accommodation question. They are subject to greater rights law. And this could also be, if it is a permanent condition, then that would then be an ADA case. Just make sure that we're taking into account what state you're in and what state your employee is in.
Okay, and please remember here that we are focusing on limitations, not disabilities, all right? An employer must make a reasonable accommodation unless it could cause an undue hardship to the organization. A leave does qualify as an accommodation, but we recommend caution with this. This can only be used if there was no other reasonable accommodation available. The stated purpose was to stop pregnant women from being forced to go on leave before the birth of their child. Okay, so please ensure that you think that a leave would reasonably help, all right? And if you do want to claim an undue hardship, we recommend speaking with a labor attorney prior to communicating that to the employee. The employer always has the burden of proof for the difficulty or expense. So we want to make sure we have thought through this. Under the ADA, the elimination of an essential function is not reasonable, but that is different under the PWFA. A great rule of thumb is to think of an undue hardship as a similar definition as ADA. These generally don't overlap beyond that, though. All right, and here are some examples of accommodations. At the end of the day, it's best to offer the accommodation whenever possible, especially with the last four listed here below. They're pretty standard and cannot cause undue hardship. So some of these examples are to allow an individual to sit if always standing or stand if always sitting. Light duty work if you offer it. Remote work if that's feasible based on the job. So again, if it is reasonable. And transfer to a vacant position. With this is only if they can't accommodate in their current position. It is not necessary to create a new position or promote them as a solution, okay? And if a claim is made, the first thing that they'll look at is what measures were taken during COVID, since that was a time full of accommodations and workarounds. And so that could really set the precedent for what you can offer going forward. And we always work closely with our labor attorneys, Fisher Phillips, so we definitely encourage using caution in any decisions. All right, for the interactive process, when a request is made, you can only ask for documentation when it's reasonable. If the pregnancy is obvious, you can't ask why they need the accommodation or ask them for a document from their physician, although they can self-confirm. If the ask is more obscure, you can ask for documentation only if it confirms the physical or mental condition that is not obvious. Examples of this would be a back injury, swollen ankles, chemical avoidance, or if it confirms that the condition is related to pregnancy, childbirth, or related, and it describes the adjustment or change needed specifically. However, this is not an all-inclusive list, okay? You can't ask for a doctor's note if you wouldn't normally ask for a note in normal situations, or if they are lactating, or if what they ask for is to sit or stand, keep water with them, or take extra breaks to eat. A written job description prepared before advertising a position or interviewing for a job will be considered as evidence for essential functions. So this is really critical. Factors to consider in determining whether a function is essential are whether the reason the position exists is to perform a specific function, the number of other employees available to perform the function, or among whom the performance of the function can be distributed, and also the degree of expertise or skill required to perform the function. It's always important to keep your job descriptions up to date so you can identify those essential functions of all positions. If you ever make changes, it's good to go ahead and update the job descriptions and save them in your files. Additional types of evidence include actual work experience, time spent performing a function, and the consequences of not requiring that an employee perform a function. All right, so next we'll move into another upcoming change, and this is about non-compete agreements. As of August of this year, non-competes will be null and void, even if they don't stand alone and are inserted into another document. And with this, you will not be able to enter into a non-compete agreement. Any current non-compete agreements will be void, and you are required to let everyone know that they are no longer subject to any non-competes that are in place already. Okay, the one exception here is for senior executive positions. But please be aware that this is actually being challenged in court as we speak, and so there may be updates coming up. All right, a notice should go out to all former and current employees, which will provide a clear and conspicuous notice that identifies a person who entered into the non-compete agreement with the worker. It must be in digital format or on paper, not verbal. And the worker is exempt from the notice if you have no record of a street address, email address, or a phone number. However, with that, you would need to have proof that you don't have this information. And since this is so important, we definitely recommend going ahead and starting your plan of action, okay, now rather than later. Use the next few weeks to really take stock of what kind of documents you have. Begin plotting alternatives. Don't ignore other restrictive covenants agreements, and get your trade secrets in order, because you won't have non-competes to fall back on. So you want to make sure that your company is protected. All right, and we wanted to take this opportunity to share with you some federal laws. And these are broken down by size of the organization, okay? Just so you're aware, last year in 2023, the EEOC received more than 81,000 new discrimination charges and obtained over $440.5 million. Yes, $440.5 million for victims of employment discrimination. This tells us that it's definitely something we need to be aware of. So here we have for under 20 employees, they must follow the state continuation, which is continuation of medical coverage if they were enrolled for 3 months. That's in Georgia. The Equal Pay Act and OSHA, okay? For 15 or more employees, they must follow the Title VII Civil Rights Act, ADA, the Americans with Disabilities Act, GINA, which is Genetic Information Non-Discrimination Act, and PWFA, which we have talked about today, and also the PDA, which is Public Display Act. And then for larger organizations, those with 20 or more employees, they must follow COBRA, which is continuation of medical coverage upon termination. And that includes medical, dental, and vision. And the ADEA, which is age discrimination. And then for larger organizations at 50 or more, they must follow the FMLA, which is unpaid job protection, and the ACA, which requires employers to offer health insurance. And with the ACA, it's important to remember that coverage must be considered affordable. Otherwise, a company could face penalties. All right, and then in regard to state laws, other state laws to consider include overtime, minimum wage, state paid leave, paid sick leave, and timing of a final check. So it's always good to make sure you're aware of the state laws that apply to your employees, even if you have just one employee in a specific state. In addition, many states are now mandating laws on job postings, pay transparency, non-compete agreements, and some even consider accrued PTO as earned wages. So again, it's important to be aware of every applicable law to your organization. There is often some confusion between right to work and at will. And so right to work just means that you can choose whether or not to be in a union. And you are not required to join a union if you take the job, okay? And at will means that an employer can terminate an employee's employment as long as it is legal, or that an employee can resign anytime. But we always recommend caution in taking any employment actions. Make sure that you're using your due diligence and to reduce the chances of litigation. All right, moving on to documentation. We always encourage very thorough documentation, again, to protect the company. Do not lead the employee to provide certain I-9 documents over others, and instead provide them a list of acceptable documents and let them choose which ones. Otherwise, it could create a potential of someone claiming discrimination, okay? If they provide extra documentation, ask them to choose which they want to keep and only store those that they choose, okay? This will be important if we ever have an I-9 audit. Keep I-9 documents separate from the personnel file. Again, this is critical to make sure we're maintaining confidentiality about sensitive information. Some additional files that we recommend keeping separate are background checks, investigations or claims, and also medical information. And the reason for this is because they contain personal sensitive information. And in regard to the situation where you need to terminate an employment, please remember, if it's not in writing, it didn't happen. So in preparing for terminations, it's always important to confirm every conversation in writing. Emails are good enough in so many cases. It's easy to just send a quick recap of the verbal conversation that was had. It doesn't have to be elaborate, but it needs to state everything that was discussed. Okay. And think of terminations as building a case with your documentation as your evidence. Okay. Worst case scenario. Always consider that your audience could be a judge, jury, agency, or even the DOL. So we always want to make sure that we can confirm the reasons for our actions. Transition agreements can offer solace to an exiting employee and limit company liability. A transition agreement is where the company promises to typically pay an employee a certain amount, and in return, the employee agrees to the terms of the transition agreement, all with the purpose of protecting the company. Okay. And lastly, please always remember to turn off system access promptly as soon as an employee is done working for the organization, because we may have someone who has been a great employee for years, but you never know how someone might react to a termination. So again, as an effort to protect the company, it's important to turn off all access immediately. And security is critical. Please consider all of the personal information that you come in contact with on a regular basis and evaluate it. Is it really stored securely? If you're not sure, maybe it's time to evaluate that and make sure, okay? Social security numbers, date of birth, any personal sensitive information should never be sent via unsecured email. There are many ways that you can send a secured email, but please make sure that you're following that. Keep information on a need-to-know basis. Honestly, the less information you collect, the less you're responsible for, okay? The less opportunity someone has to think that you are making a decision based on what information they have shared with you. Know the common scams for your industry. Believe me, there are a lot of them out there. So please stay up to date and make sure that you're aware of that proactively. Never change someone's banking information over email. We often get emails, they're sometimes vague, sometimes very intelligent, and they say, I need to change someone so-and-so's banking information, and it's a valid employee. But please make sure that you encourage the employee to go in and make their own changes for two reasons. One, you're verifying that it's that employee, and also you're making sure that what they enter is the information needed to make sure you have integrity of the information. And also generative AI. This is all new. It's a big hubbub right now, artificial intelligence technology. And it's really ramping up. So please make sure you're knowledgeable about this and making sure you're following best practices for this. And if you ever have a security breach, an employer is required to tell everyone affected. So please make sure that you're doing that as well. All right. So we've talked so much about all the different changes and some best practices. What can you do to keep your organization safe? The first thing is to create a custom handbook with policies in place to clarify expectations and update these on an annual basis. Consistency in policy adherence. It's so important because if you enforce a policy for one person and not another, there could be a potential claim of discrimination, whether that's accurate or not. Even if it isn't accurate, we want to avoid any claims whenever possible. Consistent training for those in a position of authority. We often see where people are promoted into a management position and they don't get the proper training. So please make sure that we're having everyone receive that proper training. Background checks. This is critical because it limits our unknown liability. But again, with this, consistency is needed. So we want to follow the process and decisions around a background check for all employees consistently. But it can also be clarified based on position as well. Drug-free policies. This can even get a workers' comp discount if an employer has a drug-free work policy. Documented job descriptions with essential functions identified, as we talked about previously. And documentation. We cannot urge strongly enough that documentation in writing is critical. Sometimes documentation is the only way individuals will respond. It also helps illustrate a pattern. A great rule of thumb is that if there is only a verbal conversation, it really can't be proven and it can't be verified. So it could be argued that it didn't happen, and we want to avoid that at all costs. And if you are ever unsure either about a decision, a policy, anything at all, we recommend consulting with a professional.
Okay, so it looks like that is the end of our presentation. Now we do have some questions, but before we dive into our questions, we would like to tell you a little bit about what we do here at HR Partners. So we are a full service HR firm. We offer the following services, such as a PEO solution. So this allows for savings and benefit in the benefits area, and provides customized HR solutions. We also provide ASO solutions. Now, this also allows for the above, but doesn't offer the same benefit options. And of course, we offer HR consulting services where we come in and assist with projects, audits, you name it, and we're there. We offer a great HRIS payroll and benefit system. So if you are currently frustrated with yours, go ahead and give us a call. We are offering ongoing webinars and trainings. So please be sure to sign up. You should get invites if you join this one today, but the QR code down on the bottom right does take you to our website. And again, we want to thank everyone for joining us today. And let me stop sharing my screen. Thank you, Nancy, for that great overview. It is a lot of material in such a short period of time. I know that our HR partners team will be offering a deeper dive in future webinars coming up. We will see if we can take a couple of questions, but boy, we have a lot of questions. So if we don't get to yours today, then please look to participate in future webinars that break these new laws out and go into a deeper dive, or we will try to follow up with you all next week. Okay, so Nancy, the first question is asking, does the non-compete ban apply to sales people?
It certainly does. You can still, however, address non-disclosure, recruitment, solicitation, disparagement issues separately, though.
Okay. And then we have someone who asked, should I go ahead and send out the notices required to everyone who has a non-compete?
We don't think that should be done at this point since there is ongoing challenging with it. So at this point, we recommend that you identify who is impacted, draft the communication, but then hold, okay? And we'll wait until we get closer to the date and definitely keep everyone updated on changes that are made.
Awesome. Next, we have, what if I have an employee that says they don't need benefits and wants to become a 1099?
Yeah, this can be challenging because we always want to do the best to meet the employee's needs when possible. But unfortunately, this just isn't an option. To make them a 1099 could create liability to the organization and could honestly raise a red flag. So definitely something we would be able to do.
Okay, now Nancy, we do have time for at least one more question. And that is, what if the 1099 provides their own laptop? Doesn't that meet the equipment rule?
Unfortunately not. The DOL is looking at larger equipment investments, such as machinery, cars, copiers, anything larger like that.
Okay. Okay, everyone, those are great questions, and we are so sorry that we didn't get to all your questions today. Again, please look for our future webinars coming up in the next couple of weeks. Also, please visit our website to learn more about us and our team. We have been supporting small to medium-sized businesses and their HR teams for the past 25 years. We leverage technology with a team of experts that wraps around your team to be those extra hands, relieve your stress, provide a seamless and one-top solution. We are a full-service solution versus just a technology or self-service solution. We look forward to seeing you at the next webinar, and of course, we hope you all have a great day. Thank you.
Thank you, everyone.